question, Joanna Cherry.
To ask the Attorney-General if he will make a statement about his legal opinion on the advice given to Her Majesty the Queen to prorogue Parliament.
With your leave, Mr.
General, Mr. Geoffrey Cock.
Mr. Speaker. Mr. Speaker, as the Honourable Lady knows, the Supreme Court gave judgment on this issue yesterday. And that judgment sets out the definitive and final legal position on the advice given to Her Majesty on the prorogation of Parliament. The government's legal view during the case was set out and argued fully before the Supreme Court. The hearing was streamed live, and the government's written case was and is available on the Supreme Court website. I took a close interest in the case. I oversaw the government's team of counsel, and I have to say, Mr. Speaker, that if every time I lost a case I was called upon to resign, I probably would never have had a practice. And the government accepts the judgment and accepts that it lost the case. And at all times, the government acted in good faith and in the belief that its approach was both lawful and constitutional. These are complex matters on which senior and distinguished lawyers will disagree. And the Divisional Court, led by the Lord Chief Justice, as well as Lord Doherty in the Outer House of Scotland, agreed with the government's position. But we were disappointed that in the end the Supreme Court took a different view. And of course, we respect the judgment of the court. Given the Supreme Court's judgment, in legal terms, the matter is settled. And as the Honourable Lady will know, I am bound by the long-standing convention that the views of the law officers are not disclosed outside the government without their consent. However, I will consider over the coming days whether the public interest might require a greater disclosure of the advice given to the government on this subject. I am unable to give an undertaking or a promise to the Honourable Lady at this point, but the matter is under consideration.
Joanna Cherry.
Thank you, Mr. Speaker. I also took a close interest in the case, and let me start by assuring the Attorney-General that I'm not going to call for his resignation yet. Mr. Speaker, yesterday was a very special day for Scots law and the Scottish legal tradition, going back to the declaration of Arbroath that the government is not above the law. Following in the footsteps of Scotland's Supreme Court, the UK Supreme Court asserted the rule of law, the separation of powers, and they restored democracy. And it's worth emphasising that their decision was unanimous, as was the decision of Scotland's Supreme Court, unanimous, chaired by Scotland's most senior judge, the Lord President of the Court of Session. Both of these courts unanimously found that the decision to advise Her Majesty to prorogue Parliament was unlawful, void and of no effect. But the question, Mr. Speaker, I'm interested in is how did it come to pass that this was ever allowed to happen? Redacted documents lodged with the Scottish Court confirmed the suspicion that this was a plan cooked up in Number 10 by the Prime Minister and his special advisers. But what I want to ask about is documents that mysteriously found their way into the public domain yesterday afternoon, when an unredacted version of one of the documents lodged with the Scottish Court found its way to Sky News and revealed that the Attorney-General had said that the advice to prorogue was lawful, and anyone who said otherwise was doing so for political reasons. Now, what I want to ask the Attorney-General specifically is this. I'm sure, knowing him, that his advice was considerably more detailed and nuanced than the 3 sentences that appear in that unredacted document. Can he tell us whether a legal opinion was made available to the Prime Minister or the Cabinet? The Right Honourable Member for Hastings and Rye has said that when she was in the Cabinet Ministers requested to see the advice, but it wasn't handed over. Is that correct? And can he tell us what was given to the PM, if not to the Cabinet? Because, Mr Speaker, many of us believe that the Attorney-General is being offered up as a fall guy for the Prime Minister's botched plans. So does he not agree with me that to release the advice in its entirety will help him avoid being the scapegoat for a plan that was dreamed up by the Prime Minister and his advisers? And will he give the undertaking that he has hinted that he's thinking of giving today?
I'm extremely grateful for the Honourable Lady's solicitousness and kindness for my welfare. And I am particularly attracted by the tempting prospect that the Honourable Lady dangles before me. But she will know that I am obliged by the Convention to say that I am not permitted to disclose the advice that I may or may not have given to the Government. But I repeat, the matter is under consideration.
Mr Kenneth Clark.
Does my right honourable and learned friend agree that if in the future we were unfortunate enough to have a Corbynista Labour government, obviously not thought to be a very likely prospect. But if that misfortune were to occur, and if that government were to decide to suspend the House for a long period because there was a parliamentary majority against its principal policy, and if that government also decided that constitutional law was not challenged by that and challenged the right of the courts to overrule it, the Conservative Party would be likely to get very excited. Can he reassure me that this Supreme Court judgment has settled that matter finally, that this kind of action can never be taken by any future government, and that parliamentary sovereignty therefore remains intact?
I certainly can say to my right honourable and learned friend that it is important, when we reflect upon judgments that may be seen to go against the short-term interests of any particular government, that they stand as precedents and principles for the future. And I invite all my honourable friends to reflect on precisely the situation which my right honourable friend has set out before the House, which is that this would stand for governments of a colour with which my side would not approve of, and for their actions too. And so it is important that when we comment upon the decisions of judges, we remember that those judges are both impartial and independent, and they are entitled to reach the view that they have reached. We are fortunate in this House to have one of the finest judiciaries, I believe, in the world. And it is important to remember that the principles they set apply to both sides, as the right honourable gentleman has said.
Nick Thomas-Simon.
Thank you, Mr Speaker, and I congratulate the Honourable and learned Lady for Edinburgh South West, both for securing this urgent question and indeed her work in this matter. Yesterday's decision of the Supreme Court, and I give credit to all those who brought the cases, was the most damning judicial indictment of a government in modern times. That the decision to advise Her Majesty the Queen to prorogue Parliament was unlawful. This government stands in shame, tendering illegal advice to our monarch and not even able to uphold that most basic but most important of principles, abiding by the rule of law. And what we know from yesterday's leaked document is the Attorney-General said his advice on the question of the law was that this was lawful and within the Constitution, and that any accusation of unlawfulness, he said, were motivated by political considerations. If that is in any way accurate as to his full advice, he was wrong on both counts. Yes. His close interest simply wasn't enough. Now, I'll ask the Attorney-General a number of questions. Can he confirm why it was? The government gave no witness statement to the court, and indeed the court was left in a position where it said no justification for taking action with such an extreme effect was put before the court. Why not? He talks, Mr. Speaker, about respecting the decision of the judges, but the Cabinet Office Minister was on the radio this morning saying that he disagrees with the decision.
Incredible.
Tell us which parts of the judgment the government disagrees with. And in his considerations over the next few days about the publication of this advice, can I just give him a simple piece of advice, a simple suggestion? Just publish it and make it open to Parliament and the public. Mr. Speaker, on this Attorney-General's watch, the government has been found in contempt of Parliament. Now it has been found in contempt of the law.
Incredible.
Doesn't he just accept he hasn't got a shred of credibility left?
I don't know whether, in his practice, when he was at the bar, he felt that just because he'd given advice that might not have been upheld by a court, he had no credibility. That is an absurd and ridiculous proposition. Furthermore, it was advice that was agreed with by the first instance court in Scotland and by the Lord Chief Justice of England. Is the right honourable gentleman calling for his resignation as well? Is he calling for the resignation of the Master of the Rolls? Is he calling for the resignation of the President of the Queen's Bench Division? Is he calling for Lord Doherty's resignation? I will say this, Mr. Speaker.
Order. The Attorney-General will just resume his seat momentarily. I should be deeply obliged to him. The Attorney-General has a distinctive and resonant baritone which is well known throughout the House, but it is a challenge even to him to be fully heard if there is constant catcalling. There will be ample opportunity for colleagues to question and probe the Attorney-General, of that they may be assured. But I wish myself to listen to his mellifluous tones. The Attorney-General.
I will say this, Mr. Speaker, for the Scottish Nationalist Party and for the Honourable Lady, if I may. Whereas in the Honourable Gentleman's case, no shameless piece of cynical opportunism is left on the floor, the Honourable Lady is a lawyer and a Queen's Counsel, and she knows it is the most puerile, infantile of criticism to say about a lawyer whose advice has been upheld by courts right up the way to the Supreme Court that somehow or other that advice he should be held culpable for. The fact of the matter is, this advice was sound advice at the time. The court of last resort ultimately disagreed with it. But in doing so, they made new law, as they were entirely entitled to do.
Thank you. Mr. Dominic Grieve.
Thank you, Mr. Speaker. I'm extremely mindful of the difficult task that my right honourable and learned friend has as an Attorney-General in providing advice to government. And indeed, I'm sorry if his legal advice has been partially leaked, because he is entitled to give advice in private, without which he cannot do his work. And I would also say that for him to get the law wrong in an area of difficulty is not necessarily something to be held to his discredit. But he may agree with me. But one of the issues in this matter was not just law, but propriety. And the propriety went to the unconstitutional or constitutional nature of the Act of Prorogation itself, in view of the motivation of the government for doing it. And in those circumstances, I was struck by the fact in the leaked document that his opinion is referred to as believing it is constitutional, when I'd understood from comments he made as far back, I think, as July, when prorogation was first being mooted in order to achieve a no-deal Brexit on the 31st of October, that he considered that such an act would be unconstitutional. And I wondered, therefore, if this isn't one issue which he ought not to clarify.
I know that my right honourable and learned friend will understand that it is not right for the Attorney-General, for any Cabinet Minister, to comment upon leaks of matters that have occurred within Cabinet, be they accurate or inaccurate. It would be setting a wholly undesirable precedent. But let me say this. The position some weeks ago was being mooted that Parliament might be prorogued from the beginning of September, or even earlier, until the 31st of October. I say straight away to my right honourable friend, if that had been the proposition, I could not have stayed in the Cabinet whilst it was done.
That's very different. Very different. Hilary Benn.
Thank you very much indeed, Mr. Speaker. Does the Attorney-General believe that yesterday's judgment of the Supreme Court represented a constitutional coup? And if he does not share that view, could he explain to the House why he thinks that that is wrong?
General! I don't think it was a constitutional coup, and I know the right honourable lady, right honourable gentleman, right honourable gentleman will know that I do, and I don't believe that anybody does. These things can be said in the heat, of rhetorical and poetical license. But this was a judgment. This was a judgment of the Supreme Court of a kind which was clear and definitive. It often happens that governments lose cases. We didn't agree with it because, of course, we argued against it. But we accept the ruling of the Supreme Court, and we are proud that we have a country capable of giving independent judgments of this kind.
Bob Neal.
Thank you, Mr. Speaker. Can I welcome the Attorney's very clear statement of the importance which he, and I'm sure the whole government, attaches to the impartiality and independence of the judiciary. That is most welcome. Can I also say to him that many lawyers might well have given exactly the same advice as he did on the weight of precedent. Does he accept, however, that it is most important that the convention, that the advice that the attorney gives to government is not leaked and is not disclosed, should not be lightly set aside? But would he also perhaps consider that it's rather regrettable that such an important matter, which warrants very careful and calm and considered language and discussion, should be used for the purpose of rather unworthy ad hominem attacks and a party political knockabout when so much is at stake?
Yeah. Well, I'm grateful to my honourable and learned friend's question there. I do, of course, agree with him that legal advice, and particularly the role of the attorney, is always difficult because one polices and intersects a very difficult line between giving advice of an impartial and politically impartial character and being a political minister. But I hope that I've endeavoured to do that with all of the conscience and candour at my disposal. And when I say to the House, as I do today, I accept we lost. We got it wrong on the judgment of the Supreme Court, but it was a respectable view on the law to take, and that view was taken by 4 out of the 7 judges who'd opined up to the point of the Supreme Court. The Supreme Court has made new law. Let's be absolutely clear. From now on, the prerogative power of Her Majesty, advised by the Prime Minister, can now be the subject, justiciable subject of the Court's control. And that was a judgment that the Supreme Court was perfectly entitled to make. What the implications are for the future of our constitutional arrangements will have to be reflected upon in the coming months and years. But it is never wise to reflect upon a court case and its implications in its immediate aftermath. It will have to be done carefully and deliberately, and this House will have to decide ultimately whether these matters and these powers are for this House to regulate and control or whether they are for the judiciary. But at the moment, the Supreme Court has spoken, and that is the law.
Yvette Cooper.
The Attorney-General's acceptance at that point that the government got it wrong in this case is very welcome. So will he now advise the Prime Minister and the government to accept and agree with the content of this Supreme Court judgment, not just the obligation to abide by its conclusion, and in particular to accept that it is wrong for this government or any government to seek to prorogue Parliament for 5 weeks rather than just for a few days without giving any reason, let alone, in the words of the Supreme Court, a good reason, to the public, to Parliament or to the courts that was wrong.
Hear, hear.
Well, I say to the right honourable lady that the judgment is clear. The government is assessing its short and long-term implications now, but she can be quite certain that the government will abide by its ruling and by the content and implications of its judgment.
Sir John Redwood.
What limits are there on the powers of the Supreme Court to intervene in how Parliament conducts its business? And what powers are there for them to intervene over the highly political matter of when and how we leave the European Union?
I think I understood my right honourable friend's question correctly. The court in this case, was giving its judgment on a particular issue, whether or not a prorogation of this length could be the subject of judicial control, and if so, what was the correct test to apply to that judicial control. And it chose to delineate a test which suggests that from now on, a prorogation of any length must be reasonably justified. That the court included in its analysis the fact that there was, before the House and before the country now, a particularly acute constitutional controversy, which made it even more important that the House should sit. I have to say, and I think there's nothing wrong in venturing to express respectful disagreement, but what that will mean in future is that the court will be obliged to assess whether or not a particular political controversy is sufficiently serious, excites sufficiently heated controversy, and as to warrant the House sitting for any particular length of time. But be that as it may, that is the test the court has set, and that is the test that now must be applied.
Dr. Sarah Wollaston.
Thank you, Mr. Speaker. What message does the Attorney-General have for his colleagues in government who have been smearing and undermining Supreme Court judges? Some of this is not done in the heat of the moment. We've been hearing from one journalist that he's been sent copies of articles about Iranian judges comparing Supreme Court judges with them. Is he going to give an unequivocal message to his colleagues that they should resign if they undermine the Supreme Court's independence?
The judges do not exist immune from criticism. There is nothing wrong at all in any member of the public, be a member of Parliament or otherwise, in criticising a court judgment. But what is wrong is that motives of an improper kind should be imputed to any judge in this country. We are defenders of the entire democratic constitution, and we must be sure in everything we say, and I agree with the honourable lady if this is what she means, that we do not impute improper motives. With the judgments, we can be robustly critical. With the motives, we cannot.
Jeremy Wright.
Thank you, Mr. Speaker. Is it not important, even in the course of argument on matters as important as these, to remember why we have the constitutional conventions that we do, and that government is entitled, as any other organisation or individual is, to receive legal advice in private. And if it does not, and if those who ask for it to be published get their way, what will happen is that legal advice will become increasingly guarded, increasingly equivocal, and progressively less useful to government in ministerial decision-making. And the consequence of that will be less good legal advice and less good ministerial decision-making.
Well, my right honourable and learned friend has great experience, as does my right honourable and learned friend sitting next to him, of the role which I now have the great privilege to occupy, and he knows how important confidentiality is to the ability of the attorney to give frank, unvarnished advice, sometimes unwelcome advice, to those who are conducting the policy of the government. So he's quite right. And he discharged his functions, as did my right honourable friend for Beaconsfield, with great distinction. And I'm proud to have been a successor of that.
Angela Eagle.
Mr. Speaker, the right honourable and learned gentleman has made it quite clear that the judges in the Supreme Court had every right to come to the decision they came to, and in fact they came to it unanimously in an excoriating judgment which should put the government's front bench to shame. What is his view, therefore, of a Leader of the House who persists in believing and makes it known that he feels the Supreme Court have instituted a constitutional coup? Surely he cannot remain in his post if he has that view.
There is nothing wrong with expressing robust, critical views about a judgment, insofar as it imputes inappropriate or improper motive, then it is wrong. So I think it's a question of wording and of being careful with one's language. But I took that remark, insofar as I saw it reported, simply to be a robust criticism of the judgment and nothing more, which is entitled.
Sir Oliver Letwin.
Thank you, Mr. Speaker. Mr. Speaker, I have absolute respect for the integrity and the competence of the Attorney-General. In the light of what he has told the House this morning, can he guarantee absolutely that, save potentially a few days before a Queen's speech, there can be no question of his permitting Her Majesty's Government to have a prorogation between now and the time of 31st October of this year?
What I can undertake to my right honourable friend is that there will be no prorogation that doesn't comply with the terms of the judgment of the Supreme Court.
Megilia.
Mr. Speaker, the Attorney-General said that he's going to review whether advice should be published, but in answer to the former Attorney-General, he upheld and defended the privacy of that legal advice. So can he tell the House the scope of the review he's undertaking? Is it just when the government is defeated in the Supreme Court, or will it be drawn more widely?
What I'm considering is the public interest, and whether or not there are factors in this case connected closely with the public interest generally that should outweigh the Law Officers Convention and lead to disclosure. But that isn't only my decision. I'm in the position in a rough and approximate way between a lawyer and his client. And I must ensure that there's proper consultation, proper reflection on what the public interest requires. And that I have undertaken to the Right Honourable Lady who asked the urgent question to do. And in due course, I will make my mind up.
Sir Christopher Chope.
Mr. Speaker, did it come as a surprise to my right honourable and learned friend that the Supreme Court ruled that the Act of Prorogation is not a proceeding in Parliament? And if that is the new law to which my right honourable friend has referred, would it be open to this Parliament to change the law back to what we thought it was before?
Did it come as a surprise, my honourable friend asked me. Quite a lot about the judgment came as a surprise. But that particular part proceeded from a quite strict or narrow interpretation of the Bill of Rights and what was a proceeding, and it was interpreted to apply the protection afforded by the Bill of Rights to the core and essential business of Parliament. And it was held, as my honourable friend will know, by the Supreme Court that such a proceeding, namely the execution of the Queen's Commission in the Lords in the presence of Mr. Speaker and those who attended that proceeding, was not sufficiently close to its core and essential business to attract the protection of the bill. It would, of course, be open to this House to decide to legislate otherwise, and no doubt that's one of the implications of this judgment that will have to be reflected upon in the coming months and years. I know that there was a widespread view that it was indeed a proceeding in Parliament, but the Supreme Court is as entitled to redefine, or at least to take a view of its definition of the protection afforded by the Bill of Rights, as it is to invent a new legal principle, as it did in this judgment.
Mr. Speaker, I'm sure many of us would like to congratulate the Honourable Learned Member for Edinburgh South West and Gina Miller for making sure that this remains a sovereign Parliament. The Honourable Lady asked a question of the Attorney which he hasn't answered. She asked him whether he could confirm that the Cabinet, or members of the Cabinet, and he's a member of that Cabinet, had asked to see his advice, but they were denied that opportunity. Can he confirm that his advice was requested by fellow members of the Cabinet, but it was denied?
Well, let me make plain that I have never denied any member of the Cabinet any sight of any advice of mine. I am not certain who and when else asked for that advice, but I certainly have never denied it.
Rory Stewart.
Mr. Speaker, the Right Honourable and Learned Friend agree that rather than being some newfangled, innovative decision, this was a profoundly conservative decision by the Supreme Court asserting the ancient sovereignty of Parliament, and that fundamentally the principle at stake here is that, of course, neither that court nor any other court should determine whether Brexit takes place. That decision has been made by the people. But it is for this House, the only directly elected representatives of the people, to determine the form in which that Brexit happens.
Let me say to my right honourable friend that the Supreme Court invoked the principle of parliamentary sovereignty and the the Convention of Parliamentary Accountability, ministerial accountability to Parliament, as a justification for making justiciable the decision to prorogue, and that's what it was entitled to do, and it effectively amounts to converting a political convention into a legal rule. That traditionally was not thought to be possible. The Supreme Court has decided that it is, and I certainly do not in any way complain with its right to do so. But what I would say to my right honourable friend is, I would agree with him that Parliament has to determine the terms on which we leave. But this Parliament has declined 3 times to pass a withdrawal act with which the opposition, in relation to the withdrawal act, had absolutely no objection. It was then we now have a wide number of this House setting its face against leaving at all. And when this government draws the only logical inference from that position, which is that it must leave, therefore, without any deal at all, it still sets its face, denying the electorate the chance of having its say in how this matter should be resolved. This Parliament is a dead Parliament. It should no longer sit It has no moral right to sit on these green benches, and whatever
the House must come to order. We've got a lot of business to transact. There is a further urgent question. There are no fewer, I say, for the benefit of those observing, 5 ministerial statements. The attorney must be heard, and so, I hope, will lots of other people. The attorney.
They don't like to hear it, Mr. Speaker. They don't like the truth. Twice they have been asked to let the electorate decide upon whether they should continue to sit in their seats while they block 17.4 million people's votes. This Parliament is a disgrace. Given the opportunity, since I am asked, let me tell them the truth. They could vote no confidence at any time, but they're too cowardly. They could agree to a motion to allow this House to dissolve, but they're too cowardly to give it a go. This Parliament should have the courage to face the electorate. But it won't. It won't, because so many of them are really all about preventing us leaving the European Union at all. But the time is coming. The time is coming, Mr. Speaker, when even these turkeys won't be able to prevent Christmas.
Thank you, Mr. Speaker. I think the Attorney-General will find that the moral right I have to sit in this House is due to an election called by the Honourable Lady for Maidenhead, which she lost 40 seats in. And I will represent my constituents as long as I sit in this House, and I'm here elected by the people to do so. Could he tell this House how much taxpayers' money has he spent in closing down our voice?
All I'm suggesting to the honourable gentleman is that he gives his constituents the chance of electing him again.
Order! 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 I say to the honourable gentleman, the member for Kingston upon Hull East, that as a result of my prodigious efforts last week, audiences in New York, Boston and Zurich are now aware of the honourable gentleman as the noisiest member of the House. I always enjoy listening to the honourable gentleman, but preferably when he's on his feet rather than in his seat. The Attorney-General.
If the honourable gentleman is so confident that his electorate will consider that his moral right to sit here is so strong, why doesn't he submit it to them now? All we need, I offer this to the front bench of the Labour Party, all we need is a one-line bill that we could put through with the Speaker's help, fixing the date of the general election by a simple majority, and we could have the election. Why doesn't he tell his front bench to put his confidence in his constituents to the test?
Mr. Ian Duncan Smith.
Mr. Speaker, I wonder if my right honourable learned friend, having read the full summary of the judgment made yesterday by the Supreme Court, was also struck by something that seemed to be missing within their methodology. That when they stood up, they said, for the right of Parliament to hold any executive to account, at no point in there did they reference one of the ways, of course, of avoiding prorogation or dismissing it would have been to have had a vote of confidence in the government or to have voted for a general election. Does he not agree with me that that would have been the surefire way of the opposition parties to have secured an end to any prorogation and an immediate change of government, if so wished, but they were frightened?
Yes, I entirely agree with my right honourable friend. In our constitution, when a government can no longer govern because the Parliament has withdrawn its assent, the moral and constitutional thing to do is have the courage of your convictions, which this spineless gang on the front bench here do not, to place a motion of no confidence before the House. But they haven't got the guts to put that motion of no confidence because most of them don't want their own leader in power.
Carol Monaghan.
Mr. Speaker, now, maybe say first of all to the Attorney General that none of us on these benches are worried about a general election. The right honourable member for Surrey Heath has suggested that the unanimous verdict of the Supreme Court was the equivalent of the view of just a few academics, and the Leader of the House has described the verdict as a constitutional coup. Now, unfortunately, these views do gain traction amongst members of the public. So will the Attorney General take this opportunity to give a strong statement of support both for the judgment of the Supreme Court and for the importance of the independence of the judiciary?
I think, in answer to the last point, if I may, of the Honourable Lady, I completely, firmly support the independence of our judiciary. In Scotland, in England, in Wales and in Northern Ireland, we have one of the finest judiciaries in the world. And the fact of the matter is the Supreme Court gave its judgment, and its judgment must be respected. But that does not prevent robust criticism of the terms of that judgment, which will, I have no doubt, be subjected to that criticism. That is onside. What is not onside is the imputation of improper or inappropriate motives.
Sir Desmond Swain.
My right honourable friend, the member for Chingford, is right, Mr. Speaker. We had notice of the intention to prorogue. With your assistance, we could have entertained motions against it or even a motion of no confidence. So it was a coup, wasn't it?
Well, I know that my right honourable friend will know that I want to be, if I can, and when it comes to the judges, though not to this shower, but when it comes to the judges, I want to be respectful and careful. And it is important that we should understand that these judges are protectors of all our freedoms and all our rights.
Order! I don't normally offer stylistic advice to the Attorney General, but his tendency to perambulate while orating is disagreeable to the House. He should face the House with confidence and assurance, and an acknowledgement that the House wishes to hear his every utterance. The Attorney General.
I wonder if you, Mr. Speaker, in a well-earned retirement, would like to give lessons to front benchers. It could be our beginnings of a new and very glorious, or even more glorious, career. I've now lost my thread entirely. They say they want me to sit down, so I'm going to. We'll gratify the opposition.
Mr. Barry Sherman.
Mr. Speaker, I came into the chamber today thinking I felt sorry for the Attorney General. But as he started, I did. Fair enough. But every word he has uttered, no shame today, no shame at all. The fact that this government cynically manipulated the prorogation to shut down this House so that it couldn't work as a democratic assembly. He knows that that is the truth. And to come here with these barristers' bluster to obfuscate the truth, and for a man like him, a party like this, and a leader like this Prime Minister, to talk about morals and morality is a disgrace!
I'm not sure I could discern in that marshmallow of the rhetoric any actual question. But insofar there was a question, there's an answer. If the honourable gentleman thinks that the government should no longer be governing, tell his leader to bring a motion of no confidence this afternoon. Tell his leader to agree to a simple one-line statute that fixes the election by a simple majority, and we would be delighted to meet him wherever he chooses in front of the electorate. Who will judge whether the machinations which he supports and the devices he resorts to in order to make sure this dead Parliament continues are right or wrong?
Antoinette Sandbach.
Thank you, Mr. Speaker. The Attorney-General speaks of moral and constitutional courage. Can he explain to this House why the government didn't have the moral and constitutional courage to file a witness statement in the Supreme Court attesting to the truth of the position that was being outlined to the Supreme Court judges?
I can't, I'm afraid, make comments on matters that are plainly covered not only by the Convention but by legal professional privilege. But what I would say to my honourable friend is that the government's position was set out very clearly in argument, and if she follows it all, it went on for a very long time, and the Supreme Court decided against it. We accept that position.
Mr. Nicholas Edward Coleridge-Bowles.
Thank you, Mr. Speaker. Having lost in court, the Attorney-General is keen to try his hand at another test of an election, and maybe I can help him. In paragraph 41 of their unanimous judgment, the Supreme Court referred to two fundamental principles of our constitutional law, and I quote, "The first is the principle of parliamentary sovereignty, that laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply." And that is the end of the quote. Can the Attorney-General confirm that he and the government will comply with the law known as the Benn Act, recently passed by this Parliament, that has received royal assent?
Yes.
Steve Baker.
Speaker, isn't it the case that, contrary to the shouted opinions of the front bench opposite, what the Supreme Court has done is to invent a new constitutional rule, just as Lord Sumption told us on the Today programme this morning, and Lord Sumption also said that this was a revolution. He described the decision as revolutionary. So isn't it the case that prior... She shouts shocking, it's Lord Sumption who said it. Yes, isn't it the case that prior to this revolutionary decision by the Supreme Court, it's quite likely, indeed probable, that his advice was entirely correct until the Supreme Court changed the law?
I'm very grateful to my honourable friend for the question. I can't disclose what advice I gave. The honourable lady who first asked this question had that answer, and I'm afraid I'm going to have to keep giving it today. But what I would say is that the Supreme Court did indeed, as it overtly and explicitly said, develop the law. It took what was a political convention, hitherto in all of the constitutional textbooks described as unenforceable by a court, and decided that it would set a test and convert it into a legal principle and a legal test. And that it was perfectly entitled to do, just as this House will in the coming months and years have to reflect upon the implications of it and whether it is content to leave that position untouched. But for the moment, it is the law, and the law must be obeyed.
Stephen Doughty.
Thank you, Mr. Speaker. Can the Attorney-General be very, very clear
Were the Director of Legislative Affairs, Nicky Da Costa, and the Cabinet Secretary, and indeed any other advisor, including the Leader of the House's office, asked to make sworn statements in these cases, and did they refuse to do so, and if so, why?
I simply cannot comment on matters that pertain to the internal preparations of cases which are covered by legal professional privilege. It's simply not reasonable to ask them to do so, particularly when it relates to individuals. So the honourable gentleman should make no assumptions one way or the other from what I'm saying. The fact is they're covered by privilege and they must be respected.
Vicky Ford.
There are many extremely distinguished and experienced lawyers in this House, but some of us are not lawyers, and many of our constituents are not lawyers. So could my right honourable friend, the Attorney-General, explain this very clearly? Is this a new law? Does it set a new precedent? And if it is a new law and a new precedent, will the government comply with the new law and comply with the new precedent?
What it is a new principle of law which has been found to exist by the Supreme Court, and where hitherto it has not been thought that a court could go. But that is, the court is entitled to develop the common law, and that it has done. It does set a precedent. It is binding, unless this House, in due course, should consider it should take action to alter that position.
Caroline Lucas.
Thank you, Mr. Speaker. While yesterday's Supreme Court decision was extremely welcome, upholding parliamentary sovereignty, it should never have come to this. Our centuries-old unwritten constitution, based on gentlemen's agreements, is not fit for purpose when dangerous populists are in office. Will he therefore consider urgent proposals for a written constitution developed with real citizens' engagement, since our democracy belongs to all of us, not just those who think they're above the law?
Well, I have to say I have a degree of sympathy with what the Honourable Lady says. I do think that as we depart the European Union, there is ground for thinking again about our constitutional arrangements, how they should be ordered. And in doing so, I think a widespread public consultation of the kind she's describing would be essential, because any new constitutional arrangements would have to be sanctioned by the widest possible public support and assent. So I do have some sympathy, and no doubt over the coming months and years, this will be a subject of important concern to this House.
Dr. Julian Lewis.
Given that three of the most distinguished lawyers in the country, including the Master of the Rolls and the Lord Chief Justice, found in the lower court that the government's case was entirely correct, can the Attorney-General enlighten puzzled non-lawyers like me as to why not even one out of 11 Supreme Court judges could be found to agree with them?
I think my honourable friend is asking me to look there into a crystal ball. Far be it from me to fathom the inscrutable minds of their lordships in the Supreme Court as to why they chose not to dissent if they were minded to dissent, or to agree if they were minded not to agree.
Chris Bryant.
Thank you, Mr. Speaker. I, for one, am delighted that we are sitting. But the Attorney-General is absolutely right about one thing. The result of yesterday's ruling is that all future prorogations will be justiciable by the courts. The only answer to that, frankly, is legislation by this House. My gentle suggestion is that it might be a good idea if prorogation in the future were only allowed to proceed if there had been a vote in this House in favour of it.
Well, that is obvious, if I may say to the honourable gentleman, that is as I would expect from him, particularly in his new guise as an aspirant to even higher office, constructive, helpful, impartial, and a model to us all.
That's cool. I think
but I'm not sure that the Attorney-General is seeking to help the honourable gentleman. Charlie Elphick.
Mr. Speaker, can I ask the Attorney-General that in applying this new legal principle that has been created or invented by the Supreme Court, how many prorogations in the last century would have passed muster to the test that has been created? How can this longest session that this House has had since the Civil War now be lawfully brought to an end and a Queen's speech lawfully brought forward? And finally, is royal assent a proceeding in Parliament?
As to my honourable friend's first question, plainly, if one re-examines the historical records, there is no doubt that there would have been some, possibly quite a few, prorogations that under this test might have had difficulty in passing. For example, Ramsay MacDonald prorogued this Parliament in 1930 for some months during the course of a minority government, at a time when the Great Wall Street crash had happened in 1929, and when I've no doubt that some would say the House should have sat to determine the onset of the Great Depression and to debate those important matters. But the courts looked on. They looked on impassively as that Labour government decided to prorogue. And again in 1948, and right up into the 1990s, when it was said that a Parliament had been prorogued in order to avoid an embarrassing Select Committee inquiry. And from now on, when a Prime Minister has to prorogue Parliament, he'll have to look at all the Select Committees and see what inquiries they're doing, and which chairman of which Select Committee might say, in a mortally wounded and offended manner, why to prorogue and not to allow my Select Committee to report is a matter of public importance, which I'll go to court and stop the prorogation for. So I do think that this test set by the Supreme Court invites quite a number of significant questions. I do.
Luciana Berger.
Thank you, Mr. Speaker. The Attorney-General has told us that he doesn't agree with the judgment and that he argued against it. If that is the case, and the Attorney-General was so convinced that prorogation was lawful, why didn't he and the government provide a witness statement to the Supreme Court to make that case?
Absolutely right.
Look, there are all kinds of reasons why, in judicial reviews, witness statements are not given in cases of this kind. And I cannot discuss the internal counsels of the preparations of a legal case because it is covered by an wholly appropriate, I'm sure she understands, legal professional privilege.
Stevenson.
Given that Parliament is at the apex of our constitutional system, does the Attorney-General believe that the appointment of Supreme Court judges should receive the formal approval of Parliament?
No. I understand the question of my honourable friend, and I say to him quite frankly, I think that that is a matter which this House in the coming months and years may need to reflect upon, depending upon how the constitutional arrangements of the Honourable Lady for Brighton, forgive me, Brighton and Hove, but Brighton Pavilion, indicated. Because I do think that we are going to have to look again at our constitutional arrangements. And we should see if we could find some common ground on that. We need to have a proper consideration of it. As we leave the European Union, a great gap opens up from where we take away from legal integration all of this European Union law, and we need to think about the implications of that. So I agree that one matter may very well be whether there will need to be parliamentary scrutiny of judicial appointments in some manner. I have to say that I'm not enthusiastic about it, but I understand why my honourable friend asked.
McFadden.
The Attorney's defence today with regard to the Supreme Court judgment appears to be that because the government won the semi-final, they should have been awarded the trophy. That is not how it works. And in the final, he should acknowledge that the government lost 11-0. With regard to his call, which repeats the call from the Prime Minister, for the public to break the Brexit deadlock by casting their votes. If he's so keen for a public vote on Brexit, why does he not offer the public the chance to vote on the final government Brexit deal, however that turns out?
Because I'll tell him why. Because I think it would be an insult to the millions who voted in the first to have a second one before we'd implemented the first. Secondly, that's what I think. I know people disagree, but that's a legitimate point of view. But the second thing, I think, is this. The question now of this House is whether the government is going to be permitted to govern. If the opposition does not wish to allow it to govern, then its morally correct thing to do is to seek to have an election. What I object to here is that this party and this side of the House has repeatedly sought to block that and to prevent the electorate from having its say when this Parliament is as dead can be.
Mr. Nigel Evans.
Thank you, Mr. Speaker. And following on from that, would the Attorney-General accept that the vast majority of people I talk to have great faith in this government, but they have no faith in this Remain Parliament? And whilst there are important legal implications for yesterday's ruling, the practical implications of that ruling is that this Remain Parliament that has talked about Brexit for over 3.5 years will now get several more weeks to do what they possibly can to talk about Brexit, but make absolutely certain that 17.4 million people never get what they voted for.
I wholly understand the strength of feeling of my honourable friend, and I agree with almost all of it.
Catherine McKenna.
Thank you, Mr. Speaker. The Attorney-General accepts that his legal advice was wrong, that the government got this wrong. Whether in law or not, it was patently obvious to everybody watching that it was wrong to prorogue Parliament in that way. The United Kingdom head of state was asked by the Prime Minister to agree to an illegal course of action based on incorrect advice. What does he believe should be the consequences for those responsible?
The same consequences that flow from any good faith implementation of advice that at the time is perfectly respectable and tenable advice, as this was. The fact of the matter is that the government's position was that the prorogation was lawful and it was constitutional. Now, that was the advice that the government had. It was the advice that it gave to those who asked it. And the Supreme Court has decided we're wrong. We accept that, as I've been asked. And respectable point of view.
Dr. Caroline Johnson.
Thank you, Mr. Speaker. My constituents in Sleaford and North Highcombe voted to leave the European Union, and many of them have written to me since yesterday's judgment concerned about whether that will be delivered. Can my right honourable friend, the Attorney-General, confirm there is nothing in this judgment that will prevent us from leaving the EU on the 31st of October, as they voted for in the referendum?
I think that there is nothing in this judgment that applies directly to the question of our departure to the European Union. So, as the Justices made clear, this was a decision solely on the lawfulness of the prorogation.
Mr. Speaker, further to the question by my honourable friend, the member for Grantham and Stamford, has the government been seeking a route not to comply with the Ben Act, as several ministers have made clear, and has he been asked to offer legal advice to that effect?
I can't answer the last question, as he well knows. As Attorneys General, have long maintained the Convention, we cannot disclose either the fact or content of any advice. But I will deal with the first point. There's no question of this government not obeying the law. There is a question as to precisely what obligations the law might require of the government, but once those obligations are ascertained with clarity, And I'm not saying that they aren't clear. I'm just saying that it's a legitimate consideration the government must go through. The government will obey them.
Mr. Speaker, set alongside the decision of the Supreme Court, what force in law does the decision of the British people to leave the European Union have?
The law in relation to the referendum is that it was not binding upon this Parliament. It was binding in every moral sense upon those who promised the British people that it would be implemented, but it was not binding as a matter of law.
Deirdre Brock.
The Attorney General excuses recent comments by members of this House as simply the expression of robust critical views. But wouldn't you agree that, in fact, those who were arguing recently that Brexit would give back control to the UK courts and the UK Parliament have now completely U-turned and are actively working to undermine those institutions?
No, I think that's a ridiculous assertion, in fact. I mean, the reality is that what we who believe in leaving the European Union have fought so long for is to return to the United Kingdom the power to chart its own course, ungoverned by unelected or other institutions in the European Union. Now, how we arrange our constitutional arrangements is a matter for us, and it should be a matter for us. It should be a matter for the democratic assent of all the peoples of the United Kingdom. So I don't believe for a moment that this government or this side of the House is trying in any way to avoid that. What we're trying to do is make sure those powers come back to the British people where they should reside.
Andrew Bridgen.
Thank you, Mr. Speaker. Does my right honourable and learned friend agree with me that, contrary to the repeated claims of the Prime Minister's many political opponents, that the moment he announced prorogation he broke the law, the fact is he did not? Because, as we all know now, the Supreme Court judgment yesterday set new law.
The Supreme Court judgment said that the government got the law wrong. We have to accept that, but it is perfectly true that in doing so, they effectively invented or created a new legal principle, which hitherto had been a political convention, and defined that principle in a new legal test. It's crystal ball gazing to know whether any court would decide to do that. It did, though the court below, led by the Lord Chief Justice, concluded that it should not.
Ian Murray.
Thank you, Mr. Speaker. During the Attorney General's theatrical rant earlier, he inadvertently forgot to answer the question from my right honourable friend, the member for Dellen. How much has this prorogation cost the taxpayer, and all the legal advice and all the legal consequences cost the UK taxpayer?
Answer. I don't know is the answer to that question. But I'm sure if the honourable gentleman wants to know, he can put down a written question, or I'm happy to write to him if you like. And I'm very happy to disclose that in due course once the costs are known. But I may say to the honourable gentleman, all those costs could have been saved if he just voted for an election. We could have avoided these cascades of cash falling upon so many lawyers in so many jurisdictions by the simple act of him having the moral guts and not being chicken, which is what they are.
Gerald Gillan.
On the subject of taxation, could my right honourable and learned friend advise me? These legal actions, I believe, have been part funded by crowdfunding. Will that funding be taxable, and will the tax payable on that crowdfunding have to be paid by the individuals bringing the cases?
I don't believe they're taxable, but I have to say to my right honourable and learned friend that I would need to, if she would permit me to look into it, and if she wishes, I'll certainly write to her on the subject.
Helen Goodman.
Speaker, earlier this morning, the Attorney-General set out again his long-held views about why publishing his advice is not a good idea. So has he requested a leak inquiry to discover who gave documents to Sky News last night? And if he hasn't, is that because he's worried it'll unmask machinations in number 10?
Yeah, good question.
They aren't just my long-standing views, as I know the Honourable Lady will accept. They are the long-standing views of successive attorneys of all governments over many, many years. As to the second question she asks, I am not aware whether there is or isn't a leak inquiry, but these days I'm so used to the porousness of government that frankly I use Cabinet these days to advertise whenever I need to some particular cause that I want to espouse. The reality is that this government, this Parliament, is in a position where we need to go to the electorate, and I would urge her to support that as soon as possible, because it is the only morally right thing to do, to subject these debates to the public again.
Amber Rudd.
Mr. Speaker, I must raise my concerns about the Attorney-General constantly saying that this Parliament is dead. This Parliament was elected in 2017. It reflects the divisions in this country, the divisions in our communities and the divisions in our families. The failure is that we have not yet reached a compromise. Many of us long to leave the European Union, as we set out in the referendum, but are frustrated by the fact that we have not been able to find a consensus amongst the different factions. Can I urge the Attorney-General to work with colleagues to try and find that compromise and to cease this language of pitting Parliament against the people?
I assure my right honourable friend that if I hadn't been driven to this language, I would never have used it. The fact is... The fact of the matter is that the opposition won't let the government govern. The opposition won't do what the opposition should do in these circumstances, which is vote for an election. By any standards, the government is in a minority. It's having the order paper taken over from it again and again, and no doubt further attempts to come. And that is the very definition of a Parliament that won't fulfil its responsibilities, either to let the Queen's government to be able to be conducted or to opt for a general election. That is why I call this a dead Parliament, and I do so advisedly. And I know my right honourable friend knows. Nobody worked harder than I for compromise. Nobody worked harder than I did for compromise. Nobody worked harder than I did to put through the withdrawal agreement that was put before this House. I and she worked hard to put this through. But I've now reached a sad and heavy conclusion that this Parliament's no longer worth sitting or worth the candle, and it should be gone for any good it's doing.
Dr. Philip Lee.
Honourable and learned gentlemen, the approach today probably should have had more humility and less levity, because there is widespread sympathy for the difficulty of his position offering legal advice in such challenging circumstances. In view of the fact that his advice on prorogation has been found to be unlawful, and building on questions previously, can he answer to the House whether he has been asked by the Prime Minister to proffer advice on the legality and whether it would be lawful to ignore the instruction of the Benn Act? Whether he is offered advice or not is not subject to privilege.
Words fail me, Mr. Speaker, they really do. The right honourable gentleman arises in the full force of his morality, having been elected for one party and sitting there for another. His honourable friend who did the chicken run, the rat run before him, having said already that she thinks there should be a by-election when people change their parties, he has the nerve to arise and suggest somehow that I should have affected greater humility. I think he should be on his knees to his own constituents, on his knees to his own constituents, begging their forgiveness for his betrayal. The fact of the matter is, the question is subject to the Law Officers' Convention, as he knows, and I cannot answer him. But I would suggest that when he's back here re-elected by his constituents, as no doubt he has a confidence that he will be, ask me then, and maybe I'll give him an answer outside.
Jeremy Lefroy.
Thank you, Mr. Speaker. Does my right honourable and learned friend agree with me that if Her Majesty's government chooses to push its prerogative powers to the limit, as indeed it is quite entitled to do, if perhaps not necessarily well advised to do, that it should both expect the challenge that it has had and perhaps the conclusion that's arisen from that?
I didn't hear a word of that. I'm very sorry, and I'd be most grateful.
There was a very unattractive rant fest taking place between honourable members on opposite sides of the House, each gesticulating aggressively at each other. It's a very undesirable state of affairs. Let's have a bit of calm. Let's have the question again and the answer, but we want to proceed fairly quickly. Mr. Lefroy.
Hear me again, Mr. Speaker. It's not normally you're most generous, but would my right honourable and learned friend agree with me that if Her Majesty's government wishes to push its prerogative powers to the very limits, which it is quite entitled to do, if perhaps not always well advised to do, that the kind of consequences we've seen in the last few days are inevitable?
I think that in any situation where constitutional powers are pushed to their limits, it's bound to cause strain. And I completely accept that we are in an unprecedented time now when constitutional limits are being pressed on all sides. In this House, by seizing control of order papers, by rejecting the opportunity for elections when they won't let the government govern. These are factors that place huge strain upon our constitutional arrangements. And I agree with him that it would be a good thing if we could resume calmer waters, which no doubt we will, because I have every faith and confidence in the good sense of this country and in the end the good sense of this House to be able to come to a solution, and that solution must be, I believe, a general election.
Order. A number of honourable members are standing to contribute who were not standing at the start of the statement. That of itself is perfectly reasonable, and I will seek to accommodate them if a thought has occurred to them that they want to convey or the question that they want to put would otherwise go unasked. But once those who are standing have asked their questions pithily, we must move on to the next urgent question. Clive Efford.
Mr. Speaker, the Attorney-General has really tried to take the high moral ground on this, but I have to wonder what morals were applied by the government that led to yesterday's Supreme Court decision. So can he tell the House, when was it that he first became aware that the advice that was given to Her Majesty the Queen, to the Speaker of this House, and this House itself, about the reasons for prorogation, and that those reasons were not true?
That, if I may say so, is what we used to call in advocacy terms a when did you stop beating your wife question. The reality is I don't accept the premise of the question. There is no question that the Supreme Court found in any way that any advice that had been given that was consciously or knowing misleading.
Whittingdale.
Would my right friend agree that there is a judgment which is superior to that of any courts? And that is the judgment of the British people, which has once been given on the question of whether or not this country should remain a member of the European Union, but has twice been prevented from being expressed in a vote of this House. And is it not now time that we should allow them to give their judgment on this Parliament?
Mr. Speaker, I couldn't agree with more than my right honourable friend. The time has come. the fact is this Parliament has no further point. There's no possibility of us governing while this Parliament continues to block everything it does.
Extreme brevity now required. Single sentence questions, please, without preamble. Lady Herman.
Very much indeed, Mr. Speaker. I've listened very carefully to the Attorney-General, haven't agreed with a fraction of what he has said. But I would like the Attorney-General to answer a specific question. Did it never cross his mind that if the Prime Minister made a ridiculous decision to prorogue Parliament for 5 weeks in the run-up to Brexit, which is the greatest constitutional change to the UK for years, that the courts would rule that to be an unlawful prorogation of Parliament?
If I were to answer that question, tempting though it is, particularly from my honourable, I was going to say my honourable friend, the honourable lady, but she's a friend as well, I would be transgressing the Law Office's convention, because I would be telling her what advice I had or hadn't given. But if she asked me, did it occur to me? Well, of course it did. Of course it occurred to me. Any barrister who enters into litigation, if it doesn't occur to him that he might lose, is a bit of a nit, isn't he? I mean, really. Of course it occurred to me we might lose. But the reality is it would be ridiculous not to.
Thank you, Mr. Speaker. Will the Attorney-General agree with the views of the overwhelming majority of my constituents in Gillingham and Rainham that the continued delay in delivering on the result of the referendum by the 31st of October is leading to the public having a lack of confidence in our democratic process, and the only way to resolve that is to have that election now and let the public decide?
I completely agree with the honourable gentleman. He's put his finger right on it. It is this continuing artificial prolongation of this dead Parliament is undermining people's confidence. I know why they're not doing it, because they know they won't survive. But they've got to have the courage of their convictions and get on with it and put it to the country.
Rachel Maskell.
The Attorney-General is trying to exonerate his and his government's determinations by saying that the Supreme Court created new laws, something he said at the dispatch box. Isn't it the role, and wasn't it the action of the Supreme Court to interpret existing law?
That is, of course, one function of what a court's role is, but a court is perfectly entitled to develop the common law. And I don't think there can be any doubt that that's what happened in this case.
Martin Whitfield.
Grateful, Mr. Speaker. It's often said that a lawyer who acts for himself has a fool for a client. And it's also worrying if the lawyer is not aware of the costs of the case in continuing with the advice. So could the Attorney-General, when he makes a statement about the costs to the taxpayer, include the costs to the House Authority of having to reconvene on 24 hours' notice and the inconvenience to the staff here?
Well, if I may say so, Mr. Speaker, may I place on record my endorsement entirely for your expression of gratitude to the staff of the House. They do an extraordinarily great job, and we are deeply grateful to them and grateful for the speed with which they've been able to facilitate the resumption of Parliament.
Angela Smith.
Mr. Speaker, the question of who had sight of the legal advice before the decision was taken remains unanswered. So I ask the Attorney-General once again, did the Cabinet have sight of the legal advice, and did the Prime Minister's Chief Advisor, Dominic Cummings, have sight of the legal advice?
Attorney-General. The Honourable Lady will know that I cannot disclose whether I gave advice or the content of any such advice. It is covered by the Law Officer's Convention. The question is, was the advice shown presumes that there was advice. So it simply contradicts the Law Officer's Convention. I wish I could answer a question, but I can't.
Wayne David.
Following yesterday's Supreme Court judgment, the Prime Minister presumably got in touch with Buckingham Palace and offered his apology to Her Majesty the Queen for giving unlawful advice. My question is, did the Attorney-General speak to the Prime Minister before the conversation took place?
I didn't, no.
Stuart C. MacDonald.
Mr.
Speaker, I wonder, would he agree with me that any reasonable Attorney-General acting with due care would query, would challenge and perhaps even laugh at any suggestion that 5 weeks of prorogation was necessary in order to prepare for a Queen's speech?
Attorney General. I think I understood the Honourable Justice, but I don't agree with its premise, no.
Geraint Davis.
The Attorney has accepted the Supreme Court's judgment that the government acted illegally in closing down democracy, but will he accept his duty, his fundamental duty, to uphold the rule of law and democracy and not fan the flames of hatred with the people against the courts, the people against democracy on the road to fascism, as he appears to be doing today by making fun of the Supreme Court and saying they're making things up as they go along? We make the law, they interpret the law, and he and all of us should obey the law.
The honourable gentleman really needs to listen more closely to what I say. The Supreme Court was perfectly entitled to reach the view it did. It did so by reasoned decision-making. It was entirely within the scope of its jurisdiction. But there's no question that it developed the common law in doing so. That's all I've said, and that's what courts often do.
Samjima.
Mr. Speaker, it is not fear of the electorate that drives some of us in this House. It is our determination to do the right thing by our constituents and the country against a government that is determined to deliver Brexit at any price. Mr. Speaker, you've had government ministers saying today that somehow the judgment that has been handed down by the Supreme Court could be disputed by other parties. But they never say which aspects of it they disagree with and on what basis. Could the Attorney General let us know, when ministers cast doubt on this judgment, what exactly they disagree with and why they are doing that in public?
Attorney General.
The honourable gentleman asks me about why ministers might contest parts of the judgment. There's nothing wrong with the government or the honourable gentleman or any other member of the public seeking to argue that parts of the judgment were either mistaken or poorly reasoned. I wouldn't necessarily agree with that, but there's no harm in people doing it, because that is part of democratic debate. What is wrong, and what I deplore, and what I urge all members of this House not to do, is to impugn the motives of those who make the decisions. Because these are fine judges who reach their decisions impartially on what they think is the best view of the law. And I have no doubt that is what the Supreme Court did in this case. But I'm not, if I may, going to go into all the areas of the judgment that are fragile or vulnerable to alternative arguments. The arguments of the government were set out in writing. The judgment of the Lord Chief Justice in the Divisional Court was brilliantly reasoned, was in the government's view entirely right, but the Supreme Court chose to disagree with it.
Peter Grant.
Thank you, Mr. Speaker. Despite the repeated denials from the Prime Minister, it's been obvious from the angry reaction of Brexiteers in the last 24 hours that this attempted prorogation was about Brexit and nothing else. Isn't the real reason why nobody would testify under oath as to what the government's reasons were was that even in the government nobody believed that the Prime Minister's reasons were the truth?
If the Prime Minister had wished to prevent this House from debating Brexit, he would have prorogued it from the 5th of September to the 14th of October. Because he allowed, even we knew, does it seriously suggest that the government was blind to the possibility that in the first few days of resumption after the 4th of September, that it was not possible that exactly what happened would happen? If we wished to close down all debate and prevent the option of legislation, which was ultimately taken by this House with the consent of Mr. Speaker, we could have prorogued it from the 5th, but we didn't. And furthermore, on the 14th of October, there would have been 2.5 more weeks for this House to act. With respect, all this talk about a coup is just nonsense. Inflamed political tripe, invented and inflated so that this gang can justify clinging to their green benches for another few undeserved weeks. That's what it's all about.
Ian C. Luca.
Thank you, Mr. Speaker. The authors of this failed political trick, the Prime Minister and Dominic Cummings, have fallen in treating Parliament with contempt. What is truly contemptible and what is cowardly is Dominic Cummings refusing to give evidence to a select committee and being in contempt of Parliament, and now hiding behind the skirts of the Prime Minister, who is supporting an individual who's working for the government in not giving evidence to a select committee. Does the Attorney-General think that is a respectable position?
I'm not sure it's a question for the Attorney-General. I'm sure the honourable gentleman can find somebody who's able to deal with it better than I. But what I would say is that attacking people who can't answer for themselves in this House is not appropriate, and I wouldn't myself choose to do it.
Alan Brown.
Thank you, Mr. Speaker. Will the Attorney-General explain why there is a lack of signed witness statements, or is it the case that we all know the civil servants couldn't defend indefensible and they thought the government was at it all along?
Well, as I've said in the past, Mr. Speaker, I can't answer questions about witness statements or the internal preparations of the government's case for this Supreme Court.
Alex Norris.
Mr. Speaker, the Attorney says that this Parliament doesn't want to do any work, does not wish to legislate. He is wrong. There are very, very many, very important issues that we are desperate to legislate on, none more important than the domestic abuse bill that members across this place and the other place have worked together on for 2 years now, and could easily come before this place, get this into law and make this and improve the lives of tens of thousands across the country. Will the Attorney put aside his confected outrage and speak to his honourable friend, the Leader of the House, and ask him to schedule tomorrow and next week the important stages of this crucial bill?
I certainly will talk to the Chief Whip about it. If there's a consent on all sides for this House, we might as well do something while we're waiting for them to make up their minds to go for an election.
Patricia Gibbs.
Mr. Speaker, the Queen has been misled, the law has been broken, and Scotland's Supreme Court has ruled that the Prime Minister has been less than honest. Yet there is not a hint of humility from the benches opposite. What sanctions does the Attorney-General think the Prime Minister is playing fast and loose with our democratic institutions' merits? And is the Attorney-General seriously coming before us today to tell us that the Prime Minister's position is terrible? Is it not the case that the decent thing for the Prime Minister to do is go?
Well, can I encourage her then to ensure that we vote for the election motion that will be coming before the House shortly? That way she can ensure that what she hopes, she thinks, no doubt, will take place. But the reality is, no, I don't agree. The Supreme Court found no impropriety on behalf of the government, the Prime Minister or anybody else.
Ian Paisley.
Mr. Speaker, does the Attorney-General believe that the judgment has left 17.5 million people feeling more disenfranchised than they've ever been? And how should the government and this House repair that damage?
I completely agree. The actions of this House are bringing it into discredit. It is abandoning almost all reasonable precedent. The time has come for a general election, and to resist it is immoral, unparliamentary and undemocratic. But that is a decision. That is a decision this opposition has taken. Let us wait and see what the electorate make of it. But I hope that they will understand that what this government is doing is trying to fulfil the mandate of those 17.4 million people. And we will never cease until we succeed.
Thank you, Mr. Speaker. It is reassuring to see we are indeed carrying on where we left off. As a senior lawyer himself, will the Attorney-General agree with me that any attempts to describe the considered unanimous and unambiguous decision of the Supreme Court as a constitutional coup are nothing more than constitutional bull?
I'm not sure I could adopt that language in a parliamentary way, but This was a legitimate, perfectly reasonable, proper decision of the Supreme Court. We should be proud of our judiciary, proud of its independence in all jurisdictions. I apply that to the inner house, the outer house, the divisional court. Lawyers will disagree on some of these complex and fundamental principles, and that is what has happened here.
Order. And if the point of order relates to the matter of which we've just treated, that is to say this statement, then I will, at my discretion, take it. Point of order, Emma Hardy.
Thank you, Mr. Speaker. During that question and answer session, the Attorney-General made a joke about the phrase, "When did you last stop beating your wife?" Now, part of the reason people are so upset about the prorogation is because the domestic violence bill has fallen, as my honourable friend has just mentioned. Mr. Speaker, can I seek your advice on how maybe the Attorney-General can learn to moderate his language and not make jokes about domestic violence?
Well, it's open to the Attorney to respond if he so wishes, although he's not obliged to do so. Very briefly, the Attorney.
Let me say, if I've given offence, I certainly didn't mean to. It's an old saying at the bar, which simply relates to a cross-examination technique of asking a question that presumes the premise. And it's the way in which we were taught. If I've given offence, I apologise.
I thank the Attorney for responding. This is a matter of extreme sensitivity. And what I would say to the Honourable Lady, and more widely to the House, is that it is incredibly important that we are sensitive to the wider implications and interpretation of what we say. And the mores of society do change, and sometimes one can find that things that one has quite freely said in the past without causing offence can no longer be said without causing offence. But each member must make his or her own judgment. The Attorney made his, and the Attorney has said what he has said, and I thank him for that. Point of order, Craig McKinley.
Thank you, Mr. Speaker. I apologise for not giving you advance notice for this, but it's advice that I think is very relevant to this debate. We have heard much of how the Supreme Court has extended its remit into the actions of the executive and how that may play out into the future. I wondered if you could give advice, perhaps to your successor, whether the actions and decisions of the Speaker of this House should be similarly subject to judicial review, and how that may work into the future.
I'm extraordinarily grateful to the honourable gentleman, but as an attempted point of order, frankly, in old-fashioned O-level terms, with which I'm familiar and of which the honourable gentleman is probably aware, that would get an unqualified. I'm afraid it wasn't even a good try. I don't bear any ill will to the honourable gentleman, but if people are going to have a go at these things, a degree of nuance, subtlety and ingenuity would at least command respect. But there is a grade, and I'm afraid it was way, way, way below the grade. Yes, OK. Point of order. If it's on these matters, but not beyond. Point of order, Hannah Bardell.
Thank you very much, Mr. Speaker, and apologies I did not give you advance notice. During the exchange just before, the Attorney-General said this Parliament is a dead Parliament, and he said it repeatedly, and it should no longer sit, it has no moral right to sit on these green benches. Mr. Speaker, can you advise me how we can ensure that the Attorney-General makes a statement, retracts those words, because they are beneath him, they are beneath this place. I was sent here by the people of Livingston and Scotland, as were my colleagues sent by their constituents, and our position should not be undermined by, frankly, such flippant and ridiculous language.
There is an important issue here. Is something that causes offence required to be withdrawn? The answer to that, I must say in all candour to the honourable lady, whose sincerity I respect, is no. Lots of things are said that may cause offence or provoke umbrage, and about which there will be dispute, but there was nothing disorderly about what the attorney said. The honourable lady has registered her view with considerable force and alacrity, and it will be on the record for her constituents to observe. No impropriety has taken place. And I think